international supply chain specialist. And so that's an interesting one. You're like, well, is that going to work on this? And it almost got it. So it got a published material, judging the work of authors, and authorship of scholarly articles. So it met the third criterion, but then the AEO goes and just knocks the wind out of all of them. So even though you got them, they're not good enough for this international supply and chain specialist. So they say that for the articles, for example, they presented two notable articles that covered her and discussed her work. Nonetheless, the remaining pieces in the records were not about the petitioner specifically, but articles on her area of employment in which she contributed opinions or information on the respective articles' topics. I guess maybe you could do that. That should have been argued as a published material, like written by her or something like that, or interviews about her, rather than. I guess that is considered one. I was gonna say like maybe she say she published scholarly articles in that sense, but she didn't publish herself. I guess I don't know. The article about the petitioner, without more, do not demonstrate that such press coverage is consistent with sustained national claim. And then this footnote here, which we can get into later, is she included several pieces of evidence in the RFE, including her 2023 award and her book, originated after filing the petition. So that leaves it open, like maybe this stuff was positive, that extra stuff she provided after filing, but she couldn't use it here. So maybe in this case, refiling would have been better than appealing for the AEO. That potentially may have been the argument I would make if in the denial decision they said that this stuff's good, but it's after filing, so we can't include that. The petition provided evidence that she served as a judge for the 2023 awards. So there's that judging one that they downplayed again and say it's not big, it's just one. We accepted it as criteria, but it's not good enough. And then they presented a letter that says advisory opinion does not sufficiently detail its reasoning conclusion. This advisory opinion was for original contributions. It claims that the petition has an effective algorithm for transactions and an exclusive methodology for verification of customs values. It does not explain further what those are or how they make the program a significant contribution as claimed. So one thing that happens is when they don't want to do stuff, especially when it comes to letters, original contribution, that's so discretionary that they're just weaken it out and they knock it out. Then they say next we turn to evidence submitted to show if the petitioner has earned a high salary or other significantly high remuneration consistent with this restricted visa classification. The petitioner presented a letter from her company stating her proposed salary, which is kind of weird. What, your proposed salary? The petitioner did not supply evidence of what salary she has received. So it's kind of weird, the prospective salary that she hasn't actually got paid. She should have got one and should have paid stuff for it. The petitioner also submitted an expert opinion from Dr. Blank, an assistant professor in entrepreneurship and small business at Blank. As noted above, we may use opinion statements submitted by a petitioner as advisory, but will reject an opinion or give it less weight if it is not in accordance with other information in the record or if it is in any way questionable. Here, Dr. Blank considers several pieces of evidence in his analysis, such as the petitioner's book and her award, that originated after the time of filing. So they got this letter that included this because that documentation of her background was after the fact, the awards in the book. They can't get this letter in. So this would have been one you probably should refile because there's good new stuff in there, especially an award. You knock out that category, that could get it there. I mean, could the AEO just say whatever, approve it? Yeah, I've seen them do that kind of stuff, but that just goes to how strict or restricted they want to be. There's a footnote here I haven't read. It says, we observe that some of the documentation the petitioner submitted regarding her salary, such as a 2023 bank record and documentation, the average salary of supply chain experts originated after the filing of the petition, as noted above. So, yeah, there's so much stuff after filing that happened that potentially just refiling the case would have been better for this one. I'm surprised they got 3, but I mean, who knows? If you refiled them, you might not even get those first 3 because they were pretty skeptical of it here. The 12th EB-1A AEO decision is for, it's a mouthful, a senior member technical staff information security engineer. And these kind of positions, always, I mentioned earlier, they got the judging the work of others and authorship of scholarly articles. They're easy. Not easy, but those are the ones they typically get.